Ladies and gentlemen, the first question you must answer is at the time the crime was committed, on December 5th, 2015, did the defendant have a mental disease or defect? The defendant has the burden of convincing you here, of proving to you to reasonable certainty by the greater weight of the credible evidence. So they had to prove to you, they had to prove it to you by that standard, to reasonable certainty by greater weight of credible evidence, that on that date, Brian Fatoff suffered from a mental disease or defect. And what evidence did they prove that with? What did they provide to you? Nothing. There wasn't one single piece of evidence that came from the defense that said on that date he suffered from a mental disease or defect. The only evidence they offered was from Ava Kronsky, who, going back as far as May, said she was with him at the doctor when he reported some blackouts and lapses in time, and she said she saw that again like in October or something like that. This history, according to Eva, his girlfriend, longtime friend, where he got the guns from, the place where he found the booze, that's their evidence. They provided zero evidence regarding December 5th, 2015. If on that day he suffered from a mental disease or defect, and as a result of it, he couldn't conform his conduct to the requirements of the law, and he didn't understand the wrongfulness of his conduct. They provided you absolutely nothing regarding that day. And really, your analysis can end right there. They put forth no evidence at all regarding his mental state that day. Just this background stuff. It's the same thing you saw last week during the trial. Look over here. Look back over there. Don't look on what he did that day. Look somewhere else with the facts. But they provided you nothing really could have merit. But that's not all the evidence there is. Actually, to the contrary, quite to the contrary, 3 different doctors have evaluated the defendant. Now, I will stipulate right now to you, ladies and gentlemen, that the evaluation of the Dr. Niche from Outagamie County was relevant for background information, which is the only information they provided. It's really not relevant, her finding that the defendant did not suffer from a mental disease or defect, and that he could appreciate the wrongfulness of his conduct and conformance, because it was talking about a different incident. That opinion was based on the crime he committed in Outagamie County, for which he was under the felony bond for. Now, it was relevant to Dr. Glassman and Dr. Merrick's evaluation. It was relevant to their opinions. But it's not dispositive of his culpability on December 5th, 2015. Dr. Merrick's report is, and Dr. Glassman's report is. Those reports, those doctors, those eyes into his mind, as close as we can get, scientifically, medically, opined, Dr. Merrick opined that he was malingering, and he opined that he should be held responsible, that his conduct on December 5th, 2015 was not the product of mental disease or defect. Then Dr. Glassman opined that on December 5th, 2015, under the law, he suffered from no mental disease or defect. He said he had the prior diagnoses of the PTSD, the panic disorder, and the depression disorder, that on December 5th, 2015, he was not acting under the symptoms of those disorders. And he opined on that date he could conform his conduct to the requirements of the law. He demonstrated that, and that he appreciated the wrongfulness. In fact, he said the only thing psychologically he was under the issue of was intoxication and antisocial personality disorder, antisocial conduct. 2 things that you're prohibited from by law, from finding to be a mental disease or defect. So your answer to question 1 on the verdict form has to be no. Because you've been provided 0 evidence that on December 15, 2015, he suffered from a mental disease or defect. And despite the defense trying to bring up this amnesia issue and other stuff, which the doctor found if he had it was only from alcohol, but he questioned it because he relayed the events later to Investigator Carroll when he gave a statement. Even if he would, for some reason, find, yes, he had a mental disease or defect on that day, he was not. There's zero evidence, nothing proffered by the defense, that on the date of that offense, on December 5th, 2015, he couldn't conform his conduct to the requirements of the law, or he couldn't appreciate the wrongfulness. That's just completely even left out of the defense argument, their case. So they provided you with nothing. And I ask that you find it over. Thank you.